Hello and welcome to NAP Edmonton's special event, Landlord Considerations, Canada Emergency Commercial Rent Assistance and Small Business Relief. My name is Nan Pai and I'm the Executive Director of NAP Edmonton. And I want to welcome our special guests, Millard and Ashvin Singh. But before we do introductions, I want to brag a bit about the great work NAP's been doing locally, nationally, and internationally. At the local level, we continue to do our 20 questions events. Next week, we'll be featuring Colin Klish, former NAB chair and now the chief operating officer at Point One, a developer of data centers in Canada and the United States. NAB International continues to offer courses for free right now, which are a great way to learn and improve while many of us are working from home. And nationally, we're working on this topic, commercial rent relief. Hopefully you're a NAB member and you've seen some of the information we've shared on this. We've also been profiled nationally in CBC, Global News, and City TV in just the past week about how we'd like to see this program improved. Building owners want their tenants to succeed, and it's so important that these programs are rolled out quickly, that they're simple and easy to access, and that's some of the reason why we're putting on this webinar today. Now, all of this is made possible with the support of our sponsors. Times are tough right now, and we're going to need even more industry support to make sure the crucial needs of our commercial real estate in our economy are understood and heard. So thank you to Remington, Qualico, Quadrail, and Panatoni Development, and all of our sponsors. Now, without further ado, let's introduce our speakers. Ashvin Singh carries on a broad taxation law practice representing many of Edmonton's large corporate groups and high net worth families in relation to tax planning matters and disputes with the Canada Revenue Agency. Millard's practice focuses on trust and real estate law, complemented by a vast experience in corporate, commercial, and real estate law. Both take pride in working extensively with commercial real estate developers and crafting innovative legal solutions to meet the unique needs of our industry. Welcome, Ashvin and Michelle.
Keep growing in light of all these programs. I'm joined, of course, by Millard, who practices in wills, estates, and trusts, not real estate estates primarily, and but does have a vast amount of commercial real estate experience. So both of us have done lots of tax optimization work for the real estate industry, and so we're so grateful for the opportunity to present here today. So why are we involved in all of these relief measures? Well, the reason is, of course, that a lot of them are CRA administered and implemented through tax legislation. And despite the fact that the intention is that they be broad-based and accessible to a large number of people, many are not an easy read. Lots of them were implemented through dozens of pages of pretty mired tax legislation. And so we've kind of sat at that juncture of interpreting those programs for our clients. So in terms of how our presentation will be outlined, I'm going to be addressing what I probably call the tax-driven relief programs unveiled by the federal government. So the various programs and benefits that have been developed over the past few months. And, I promise to keep this fairly high level. I know it's a gloomy day outside. I don't want to put anybody to sleep. But the goal will be to kind of convey a broad awareness of all the programs available and answer some of the questions that we've been encountering as advisors on those matters. And hopefully that'll help you in determining whether, it might be of assistance to you in your own life or, somebody close to you who might maybe need access to those programs. Michelle is then going to be talking a little bit more about the finer points of the program that you're probably the most curious about, which is the Canada Emergency Commercial Rent Assistance Program, because as I'm sure you're aware, a whole bunch of new information was released this week and applications open on Monday. So just by way of introduction, I've developed this abbreviated timeline of selected events, and what I want to illustrate here is it's almost like the government has started dealing with this crisis by chiseling away at a statue. That's probably not the greatest analogy, but they're addressing these broad chunks of people who are out of jobs through the CRB, and then gradually addressing narrower and narrower groups, culminating, of course, toward the right side where we have student benefit programs for students that are finishing their academic years, and of course, the rent assistance program. So there's kind of a narrowing of addressing different groups and their needs, and I have no doubt that we'll see more programs continue to be unveiled in the next few months. I guess I like infographics. This is another kind of way of conceptualizing it. I think the government's looking at the map of societal stakeholders, everything from employees to students to small business owners, and gradually extending its way over that map. So on the left side of the page, you see all the programs that have kind of been unveiled to deal with employers, the wage subsidy program, that kind of thing. And on the right side, you see all the programs that are assist employees and workers, like the EI and the emergency response benefit. So without further ado, I guess I'll go right into some of the programs and an overview of them. The first one that we wanted to talk about is a supplementary unemployment benefit plan, or SUB plan. And this isn't something that most people would have heard of outside the context of mass layoffs, but of course that's a relevant consideration in the era of COVID-19. So generally speaking, without getting into the weeds, a SUB plan is a severance mechanism. It's a plan registered with Service Canada that allows you to increase an employee's weekly earnings if they're unemployed due to a temporary work stoppage, which would include, of course, temporary layoff due to COVID-19. And so it enables an employer to supplement the maximum of $573 per week. So essentially, the employer says they're going to top up EI. And why would they do that? Well, it happens to not reduce any employee's EI benefits. So if an employee generally gets other employment or receives other earnings, that reduces and grinds the amount of EI they can collect. And it's a goodwill measure. It reduces the hardship of a temporary layoff. And could be part of a kind of a creative agreement not to have the employees sue for wrongful dismissal. So these plans, you know, they do have to be registered with Service Canada, and setting them up is a little bit intricate. But once they're established, ongoing payments to the plan are fully deductible, just like wages. So we've seen lots of clients setting up these plans to assist laid off employees through hard times. For employees that aren't lucky enough to have that top up, of course, the most common assistance program that we're familiar with is the Canada Emergency Response Benefit. So, you know, this is an arguably imperfect but broadly focused program that's designed to get cash into the hands of Canadians who are out of work due to COVID-19 as quickly as possible. So the federal government stepped in and created this allowance of $2,000 a month for persons who have stopped working due to reasons related to COVID-19, are eligible for ordinary EI or sickness benefits, or have exhausted their ordinary EI benefits. And there, you know, initially when this was introduced, you couldn't earn any income. So the argument was made by commentators this was a deterrent to doing anything or even earning some kind of small de minimis amount of income through consulting or something like that. So now there's kind of a threshold of how much income you can earn during a period when a CERB claim is being made. So right now it's $1,000 that you can't earn for 14 or more consecutive days within the period of a claim. Applications for this are being administered by the CRA, Canada Revenue Agency, and Service Canada. And the way it interacts with your EI entitlement can be a little complex, and you can't double dip. So the collaboration between those two organizations allows them to harmonize the benefits. So the questions we get largely have to do with eligibility for the benefit. Namely, people have asked, if my revenue declines substantially, I'm a business owner, can I do, no, you have to actually have stopped working due to COVID-19, even though there's that $1,000 income threshold. And the guidance that we have received is that a lot of the payments will be audited, and folks that receive it improperly will have to pay it back. I don't know if anybody saw that article in the National Post on, I think it was Monday or Tuesday, that the amount of CERB recipients exceeded the increase in jobless persons by about a million. So not clear if that's some kind of timing anomaly or foreshadows some audit activity down the road, but we have that to expect if people are on the fence about it. I know nobody here is likely to be a student, but just for the sake of completeness in addressing all these programs, I want to touch on this Canada Emergency Student Benefit because it's relevant right now because the program is just starting. So this is a program announced on April 22nd, 2020 to provide a benefit of $1,250 per month to eligible students between May and August of 2020, or $2,000 per month to students with dependents or disabilities. This is generally available to students who are in a recognized degree program, finished or ended their post-secondary studies in December 2019 or later, so they're in high school or finishing high school. And the applications opened on May 15th, 2020 through CRA's My Account. So that, this is again a stopgap for students who are unable to obtain employment. There's been further announced, but we haven't seen details yet on it. There's been further announced a Canada Student Service Grant that provides between $1,000 and $5,000 to students who volunteer during the pandemic. So it seems to complement the student benefit for those who can't find work, but we don't have precise details on how that's administered yet. The party line seems to be stay tuned. So now off into the programs that are employer targeted. So the temporary wage subsidy for employers. This dates back to March 25th, 2020, which seems like a long time ago. That we might remember that was when the lockdown measures were just starting to be rolled out. And so this is one of the early programs unveiled to tackle COVID-19. And the essence of it is a quick and dirty way to support employers and businesses by subsidizing paychecks. So if I can digress a minute, why was this done? Well, early on in the pandemic, we had the benefit of the experience of certain countries that have had COVID eruptions before we did. And those experiences led to experts and economists to believe that preserving employee-employer relationships really expedited and facilitated getting the economy back on track at the end of the lockdown period. And conversely, the breakdown of that relationship through layoffs led to a lot of problems, a loss of trust, psychological issues like a lack of self-confidence and self-worth on the part of laid-off employees, and generally just more friction in returning to some kind of semblance of economic normalcy. So early on, the government said, if you're an eligible employer, we're willing to subsidize 10% of your wages up to $13.75 per employee and $25,000 per employer. And to make it really easy, rather than going through some kind of intricate application process, you can just reduce the amount you owe us every month by the amount of the subsidy. And how will you know if you've done it right? Well, at the end of the year, we'll true everything up, we'll reconcile it, and everything is good. So what the questions we're getting about this were, well, what if I wasn't aware of the program at the time it was released, or I didn't want to start reducing my remittances and have a debt at the end of the year, so I didn't take the subsidy? Well, the answer there is in many cases that you can just take the subsidy now by reducing the remittances in a future period. So like I said, it's a quick solution. It was strong action right away, but it obviously didn't address the broader problems due to the focus on very small businesses. 10% isn't a lot of wages, and $25,000 isn't necessarily a lot of money in a crisis scenario. So following the temporary wage subsidy, the federal government was still starting to see these massive employers with unaddressed issues. We saw like Air Canada, WestJet, others start to contemplate mass layoffs. And so the next program to be unveiled was this Canada Emergency Wage Subsidy, or CEWS. And I don't know why the tax community has decided to give all of these programs some kind of moniker. So what is CEWS? Well, CEWS is a broadly available program that's intended to support employers and keep employees employed. It's not limited to certain employees, so it's broadly available. So even if you're a C-suite executive or an owner manager gets paid by salary, that would qualify. And there's a per employee cap to the program, but no maximum limit for employers in aggregate. It's administered through the Income Tax Act. The amounts that you're entitled to are kind of deemed to be an overpayment of taxes, and they're paid on an entity by entity basis. So I'll try to go through CEWS a little bit at a 30,000-foot level because, as I said earlier, some of these are quite complex and probably not very interesting. But generally speaking, if you're an eligible entity that has employees employed in Canada and you've seen a revenue reduction amount, you're entitled to the subsidy. So in March, that amount was 15% in revenue versus what we call baseline revenue. In April and May, that was, you had to show 30%, I guess, because those months had 2 times the amount of a crisis period. We started to shut down in mid-March. And we just heard on May 15th of 2020 that this program will be extended for another 12 weeks into August. But we don't have precise details on that yet. And specifically, we don't know what the revenue reduction threshold will be because, of course, we do have a partial reopening now, and some businesses are able to operate. The revenue reduction is measured by comparing that revenue in the relevant month with what we call the prior reference period, which can either be the same month in last year, or you can also use the average of January and February of this year. So whichever one's more advantageous to you. And I'll just flag that the revenue decline rules are super complex depending on how your business is structured. For example, if there are multiple corporations in a group, there's some very intricate rules for how you aggregate and compute revenue. But suffice it to say that a lot of the questions been asked about this program have to do with that revenue computation. And so obviously happy to answer queries offline if anybody has any questions about that. So what do you get if you're eligible? So, well, for each of your eligible employees, you get 75% of their baseline remuneration up to $847 a week. Baseline remuneration is generally the average of what they were receiving between January and March of 2020, excluding weeks where the employee was not remunerated. And the goal is to have those employees kept on at their full wage, but you don't have to do it. So in effect, the employer could decide to reduce an employee's salary with consent to like 75% of pre-crisis levels and have that entire reduced salary subsidized by CEWS. I note there on the slide that there's special reduced rules for seasonal employees. So this week, actually, we had some people, I guess, raise the concern that that January to March period, some people don't earn income during that period, or they might have been on maternity leave or something of that nature. So now there's an ability to look to last summer, from March 1st to May 31st, 2019 period, to calculate that baseline remuneration to see if you can get the full $847 a week. How is it administered? So I think, I referenced earlier that CRA is administering a lot of these programs. CEWS is one of the main programs that's occupied a lot of their human resources. So CRA is to administer the subsidy program and is providing interpretive guidance. They've told us they're auditing this at the outset because they're cutting some absolutely enormous checks to businesses right, left, and center. But it's focused on blatant abuse. For example, payroll amounts that are completely out of line with historical precedent. Or fraud and double dipping, and they're not concerned with issues around the margins. So an example given was, we're not going to, at this point, be auditing a 29% revenue decline versus 30%. But employers should be sensitive. A lot of the questions we're getting are reduced around taking around the subsidy during a tumultuous time, and there are significant penalties, and obviously making a false statement to the CRA is a criminal offense. And there's these very unique name and shame provisions that were put into the legislation that essentially entitle the Minister of Finance to publish people who've applied, or I guess employers who've applied for the program. So unclear what the intention was, but certainly one potential reason would be to provide the names of those who have abused the program. Application period for CEWS opened on April 27th, we saw that April. Applications were processed pretty quickly. Between April 27th and May 3rd, we saw most of the applications processed by the 4th, and that just kept on ongoing as people compute their revenues and apply for each particular payment period. And there's a calculator help you out. The CRA has a published calculator on their CRA website. Only the most initial issues that we've had with this subsidy have to do with the way that it interrelates with the temporary wage subsidy that I referenced earlier. What happens if you've already taken the 10%? Well, they actually kind of assume for the purpose of CEWS that you've taken the 10%. So if you haven't done so already, that'll be reduced from the checks that you get for the CEWS subsidy. So you'll have to, figure out how to make those work together. A few final points on CEWS. First of all, retroactive reinstatement of employees is strongly encouraged. So the CRA has come out and said if you've been laid off or furloughed as a result of COVID-19, you can become eligible retroactively as long as the employer rehires you and your retroactive pay and status meet that eligibility criteria that I talked about earlier. Definitely attractive because the maximum CEWS amount of $847 a week is greater than the maximum CERB amount. And for all the reasons I discussed earlier, it's better to have people working than not working. There's an additional subsidy for eligible employees that are on leave with pay. The subsidy amounts are included in the employer's income for tax purposes. It's deemed to be assistance from a government. And I should mention this also in relation to CERB. Most of these subsidy amounts are taxable. So even though the government, in the CERB context, for example, is willing to cut $2,000 checks right away, somebody who's earned other income in the year by the end of 2020 should expect to have to remit a certain portion of that with their 2020 tax filings. So just another thing for employers and employees to keep in mind. Canada Emergency Business Account. So a big criticism of that emergency wage subsidy is the sheer amount of time that it was taking to disperse funds. So initially, the federal government said it might take up to 6 weeks to actually make those direct deposits, and obviously that's coupled with a whole bunch of cash flow pressures that businesses are facing, rent and mortgages and property taxes and whatnot. So this program was meant to, I think, to assist small businesses at least with that cash flow crunch, and it's basically a $40,000 interest-free government guaranteed loan available to small businesses and not-for-profit organizations. And If you repay it before December 31st, 2022, you get a quarter of it forgiven. And initially there was an eligibility restriction that was you had to produce a certain amount of payroll, $40,000 in payroll. Then that was reduced to $20,000 in payroll, and now they've issued a further expansion, basically saying that, you know, if you have eligible non-deferrable expenses between $40,000 and $1.5 million a year, you're eligible for the program. And then those include things like rent, property taxes, utilities, and insurance. We picked a really fun week to be presenting to you because a lot of these changes happened this week. So the advice we've been giving is that if you are eligible, it's kind of a no-brainer. The process involves, you know, 3 clicks on your financial institution's website, and the amount is ultimately forgiven. But obviously, you know, you have to navigate through the rules and make sure that you comply with all the requirements. Again, another program I'm just mentioning for the sake of completeness, and I really won't try to get into the weeds here, but this also was released on May 11th, 2020, so recently. This is a financing program that was unveiled to provide assistance to large employers to support the maintenance of Canadian business operations. So they basically said, you know, to any employer who either has some significant impact on Canada's economy through all their operations or the size of their workforce here, that these facilities will be available and they have to be applied for. So, you know, do reach out to us, as we've helped clients work through these programs, but probably not germane to the small business theme here. Okay, well, last but not least, this is the program that's likely on everybody's mind in this group, and that's the CECRA, CERSA. You know, we've heard different nicknames. So this was announced at the end of April, around the 24th, if I recall correctly. And I know this has been a marathon for NAIOP, which has done some incredible and immediate advocacy on the program. And it felt like a bit of a struggle for us too, because we sit at that juncture of law and finance, and we've received lots of questions from clients, and the answer has ultimately been, yeah, we don't know what yet, what the logistics are going to look like, which is hard because we've seen the struggles of landlords and tenants in this economic climate. Real estate is one of the biggest expense drivers that has caused pressure points. So what we're relatively happy to see is that as a consequence of releases this week, we know that applications are intended to open on May 25th, and a lot more detail has been unveiled. So high level, what is this? So it's a voluntary landlord targeted relief program available to commercial property owners, administered by the Canada Mortgage and Housing Corporation, or CMHC, probably more famous for its high ratio mortgage insurance. And the program is a subsidy. It's a subsidy of 50% of the rent payable during 3 months of 2020, April, May, and June, to landlords who are willing to irrevocably offer their eligible small business tenants a reduction of 75% of their rent. So, you know, to cut to the chase, landlord's got to absorb 25% and also has to agree not to evict tenant during the subsidized months or 3 months after they have applied for the program. Here's our laundry list of eligibility criteria. So, you know, for the landlord, they must own commercial real property in Canada. They've clarified actually that the holder of a long-term lease is eligible. The example given was maybe an airport that holds like a 99-year lease or something over a piece of land and buildings. That owner, quote unquote, is eligible for an application of the program. The landlord must have reported commercial rental revenue in 18 or 19 or commenced receiving it in 2020. The real property has to be occupied by impacted small business tenants. We'll get to that definition a little bit later. And there's got to be a legally binding rent reduction agreement that reduces the rent of the tenants. Landlord has to have applied for other non-repayable rent assistance programs, or if there's some form of contingency insurance they'll pay out, they have to represent and warrant in that loan forgiveness agreement that they've done that. And the agreement has to include a declaration of rental revenue and a moratorium on eviction, during which the owner agrees to apply the loan proceeds. I want to note here that they've said in the frequently asked questions they answered this week, they've clarified that there's no non-arm's length requirements. So that means that if you own the property in which your business is situated, you are eligible for this program so long as there are a few requirements met. And those are particularized in the actual documents. But broadly speaking, if there is a valid and enforceable lease agreement that was in place before April 1st, and the lease is set at market rates, there should be no reason why you shouldn't apply for the program. What's an impacted small business tenant? Well, it's a business, nonprofit, charitable organization. Again, the definition is very broad. You have to pay no more than $50,000 in gross monthly rent per location. Um, you must have ceased operations or experienced a 70% decline in pre-COVID revenues. And you must generate no more than $20 million in revenue on a consolidated basis. So two things I want to note here. The first is on that revenue decline. We're advised that the revenue decline can be compared to either the same months in April, May, June in 2019, or the average of January, February of 2020. And that'll sound familiar because that's the exact same rule that's been used for the CEWS calculation. And they haven't given us any guidance here. There's no legislation. This is a purely contractual program between CMHC, landlord, and tenant. So, but I think it would be fair to say that if there was a borderline case, the way it would be interpreted would be very similar to the way that CEWS is applied. So a lot of the same complex revenue calculation rules. So that's some of the work that we've been doing or working through with clients, is to say, okay, well, let's assume that the rules are parallel, or those rules should guide your interpretation of the 70% decline. The other thing I thought was kind of interesting is the CMHC was asked about the computation of that $20 million in a big corporate group, and they've kind of said, well, if it's got to be ultimate owner, right? Whatever that means. It's not particularly a robust legal term, but what if you're not preparing consolidated financial statements? And they've said, well, if the small business tenant and its ultimate owners produce consolidated financial statements, then you use those financial statements. If not, the tenant is considered on its own. So, that creates a potential for situations where, the $20 million revenue threshold is met, but for whatever reason, the corporate group just doesn't prepare consolidated financial statements. So worth considering in your own corporate group, whether those consolidated statements are prepared and how that impacts your eligibility for the program. Okay, I'll turn it over to Michelle to talk a little bit about administration points.
Thanks, Ashvin. Before I jump into the administration process, I would mention to you that Ashvin has been very, very helpful and instrumental in assisting my clients with information that they're seeking on these programs. So a whole host of programs available, lots of choices for both employers and employees, but they are complicated. So I've been passing information through to Ashvin, and he's been responding directly to the client. So I would recommend him to you if you have questions on these programs. And of course, the goal is to keep the economy going, and if we can all achieve that, that would be a win for everybody. So getting into this rent assistance administration process, as Ashvin mentioned, the applications open up on May 25th, and they continue to be open until August 31st. They have staggered the application process. So if you are an Alberta landlord and you have less than 10 tenants, then you can apply on Monday. If you have more than 10 tenants, then your date for eligibility will be on Thursday. And then Friday, it opens for all parties. And there's different allocations of provinces on the website. We've got a link to the website later on that has some more details on that. So if you want to go and look at that, you'll be able to use our link. So one of the things that's required, and again, when we've been working through this, we've been waiting as things come about, but they have given the sample tenant attestation agreement, a property owner attestation agreement, a rent reduction agreement, and a forgivable loan one. And they're all posted online. They have lots of good information in them. You would have to decide whether or not you need to reinvent the wheel on some of these, or you just want to use these. And there's a judgment call with all of that. One of the things that we note is that there is a requirement for an integrity declaration for both the tenant and the landlord. So they're trying to convey that they want property owners and they want tenants that are not involved or haven't historically been involved in fraudulent transactions, aren't doing things that would be determined corrupting, money laundering. They haven't been ineligible to deal with the government under its integrity regime program. So lots of limitations. You need to be looking good, I guess, in the eyes of the public. They've also got another limitation that the property owner can't hold a federal or provincial political office, and the property owner can't be involved in promoting violence, inciting hatred, or discrimination. So again, the perception is that this is helping good tenants and good landlords. A couple of limitations on this. One of them is that the lease can't expire before August 31st, 2020. So you may end up in situations that this may not apply. Could you do a renewal? Can you do something to extend that? That's a question that we haven't got a clear answer to, but something that you could consider if you're a landlord and you're trying to make use of this program. It can be used for newer businesses, and instead of comparing to revenues from 2019, you could be comparing revenues to January and February of 2020. And so, thank you. So then ultimately, those revenues may be able to be used. So that would work if you were in business at the beginning of 2020. You might find some holes if your tenant started operations in April or May. For non-arm's length parties, as Ashvin mentioned, there is the ability to use this, but the lease has to have been in place before April 1st, 2020, and there can't be any amendments to it. One of the other pieces of the equation is that when the landlord applies, it applies for 3 months, April, May, and June, and all the applications take place at the same time. The forecasted revenue can be used for the month of June. And so a piece to keep in mind is whether you could make the application for less than the 3-month time period. We don't think that that's possible. We think it is for the 3 months. And so you might have a tenant who has very low or no rental revenue, or business revenue for April and May, but back to normal revenue for June, and whether or not they qualify will be a question of fact. If you can flip to the next slide. Thanks, Ashvin. So the subsidy is provided by way of a forgivable loan, that would be given to the landlord, and that would be given to cover 50% of the gross rent. And we've talked a little bit later about what that gross rent is defined as. It will be interest-free and be forgiven on December 31st, 2020, as long as the terms of the rent reduction agreement are adhered to. So a couple of pieces to that. If the tenant attestation document is not truthful and the landlord becomes aware of that before they've been given their loan, they have to notify CMHC. If they become aware of it after the loan has been made to the landlord, then the landlord has to sue the tenant in a normal way for the shortfall. And then they have to use any monies that are recovered to repay the CMHC loan. What isn't completely clear from the information on the website or the agreements is if the money comes in, if the landlord is unsuccessful in collecting the money, then what would happen is the loan still forgiven, or is the landlord on the hook for that? So not clear about what that outcome would be. This is an unsecured loan that's going to be given by CMHC, and it is interest-free unless there's a default. Upon default, the interest accrues at 5% per annum. And the purpose of the loan is to refund the money to the tenant or have it credited against future loan or rent payments. The money that the landlord receives has to be used to, as I said, firstly repay the tenant or credit the tenant, and then it can be used to cover off expenses. And so we've contemplated what happens with that extra 25% if it's a triple net lease and there are no expenses that the landlord's covering. And I think the answer is there's never none, because there's probably the a chunk for the insurance. But at the end of the day, is there any concern with the landlord keeping that extra money? Don't have a clear answer on that. We think that practically there's not going to be many of those. Another thing to consider is if that rent reduction agreement is going to put the landlord offside of the covenants that it has with its own lender. And if so, you're going to need to get those consents in place with your lender. So keep in mind that that's often a term of the bank loan from a third-party lender. So make sure that you've got that addressed when you're working through this with your lawyer. And then again, I think I mentioned, but if the loan's not forgiven, then it has to be repaid by the landlord after December 31st. And the last point that I'll make on this slide is that whether the tenant gets a refund or the tenant gets a credit for future month's rent, that choice is up to the tenant. So the next slide is a definition of gross rent, and that's coming directly from the website. So we were pleased to see that it's not only the base rent, but also the regular monthly installments for the operating costs. That was a question that we had when we were doing this presentation a few weeks ago, and I had actually guessed that it didn't include operating costs, but I guessed wrong, so that's a good part. Some of the things that are excluded, and you'll want to go through this, is where the tenant is paying the utilities directly or paying the property tax directly. That's excluded from this calculation of gross rent. But I think it's a fairly clear definition, and when you figure out where you're at, you can slot in the numbers into the rent reduction agreement. One thing I will note is for the operating costs, the terms of the rent reduction agreement provide that there is a requirement that the landlord not recover from the tenant any of the rent reduction. So whether that's the base rent or even the operating costs. So when you do your reconciliation at the end of the year, if there's money owing back to the landlord, you have to calculate it and look at what credit is being given for the months, the target months. And the target months are defined as April, May, and June. So if the credit relates to those target months, you exclude that, and that does not get credited back to the landlord. So considerations from the landlord's perspective is the rent reduction agreement specifically says that you cannot evict as a landlord for the 3 months that you're giving this rent reduction, or from the time the application is made, which would start on Monday at the earliest, until 3 months after, and it's the later of those two time periods. And you have to agree not to evict for anything related to COVID-19. So what it doesn't say is that you still can evict for other items. So if there was a breach of an environmental covenant, then you would be able to evict for something along those lines. Is it beneficial for the landlord to do this or not? It becomes a business decision. So it's less on the legal side and more on the business side of the equation. I think you have to assess each situation. So there's not a one answer fits all. For each landlord-tenant situation, you're going to have to determine what's going on with your tenant. Is your tenant making payments on a regular basis? Did they miss payments for January, February, March? And this is continuing for April, May, and June. If that was the case, and you're unlikely to collect for any of those 6 months, maybe you'd be successful in collecting at least 50% of the rent for the 3 months. So again, it comes down to a business decision. On the other hand, if your tenant is in breach of the lease for a whole host of other reasons, and you are further prevented from evicting them, well, then you may make that decision that doesn't make sense. So you're going to be looking at, is there another tenant at the ready? Could you get someone else to fill that space right away? And considering that it's a little bit more of a difficult economic scenario, I would suggest that may be more difficult to fill than in normal situations. So thinking about the solvency or potential solvency of the tenant is huge. Thinking about whether there's guarantees that are in place, all of that sort of thing are relevant to all of these assessments. So I think at the end of the day, it's not a yes, this makes sense for me, but it's an assessment as to what is your downside risk, what's the cost benefit analysis, and then once you've determined that, you can decide to pursue it or not. Going on to the next slide. So the sample agreements don't necessarily make sense for all leases. Having said that, you probably have to think about the costs of having a tailored agreement. So always nice to have a perfectly ideal tailored agreement for your situation. I am guessing that if your tenant's suffering financially, you may be unsuccessful in collecting back the cost for your lawyer to prepare that kind of an agreement for them. So that's something you're going to have to really think about. The agreements, as I said, are not bad. You'll need to go through them and make sure that they do make sense for you, but they're easy to read and something that you can probably work your way through without a lot of concerns. One of the things that we would note is in the forgivable loan agreement, which is the agreement between the landlord and CMHC, this agreement can be terminated if there's insufficient funds coming from the government, which would indicate to us that you probably want to be on the early side of making these applications in case there is some shortage of funds that's coming at the end if you're at one of the last to apply. The other thing is that in the forgivable loan agreement, it speaks to the fact that each party has to bear their own costs, and that's between the landlord and the tenant, the landlord and CMHC. There is not a similar clause in the rent reduction agreement. So the fact that that clause is not included in the rent reduction agreement suggests that there may be you may not be in an easy situation to go back and collect from the tenant for the cost of preparing that agreement. What are the landlord's risks? Well, if the agreement that the tenant provides, a tenant attestation agreement, is incorrect, then the tenant, the landlord has a duty to sue the tenant or to notify CMHC if it hasn't received the loan yet. They would have to return it if there was a misleading statement. But as I said earlier, it's not completely clear that if they don't collect that they'd have to repay the entire amount. So lots of different parts to the equation. One of the questions that we are contemplating is, again, when you do the assessment on the business side from the landlord part of the equation side, this makes sense. I would collect something more than zero, or something more than 25%, so you can get up to 75%, 50% coming from the forgivable loan, 25% from the tenant. Then maybe this is a better program than potentially trying to sue a tenant that has virtually no value. If they're insolvent or they're claiming bankruptcy, you can't get blood from a stone. So then in that case, it makes sense. One of the questions, like I said, that we were asked is, well, what happens if you don't pursue this program and then the tenant doesn't make the payments and then the landlord sues the tenant? Is there a duty, or would there be a duty for the landlord to have mitigated their losses by applying to this program? So we don't have an answer for that. If we're talking to tenants, we're saying, you know what, you as a tenant should be asking for this, making a pitch to the landlord about why you think this makes sense. And if you've got that pitch and you've got something in writing and the landlord refuses to do that, that may be evidence that you bring forward in the court if there is a lawsuit. So from the other side of the equation, that may work against the landlord. So keep that in mind. The website location is on the bottom of this side, so you can go in there. And as I said, there's a sample agreement for the rent reduction, for the forgivable loan, and the tenant and landlord attestation. And then just to wind this up from my part of the equation, it's an ability to get probably 50%, maybe 75% from a tenant that you may have received nothing from during that 3-month period. The process of going through an eviction is, of course, time consuming. Our courts are closed or at reduced capacity at the very least. I know they're starting to open things up, but at this time, it's not easy to go through an eviction process. In our economic environment, it's not easy to find new tenants. So some contribution to your rent and to your op costs is better than nothing. And then keeping tenants in business might be a long-term win for you if you can keep this tenant viable and you can keep your relationship viable. So it's not for everybody, and there may be places where landlords can't make this application or tenants don't qualify. But if you do qualify and your tenant qualifies, it may be worthwhile to think about this. I'm going to turn it back to Ashvin to wind this up, and then we'll go into questions.
Awesome, thanks, Michelle. Well, I know Anand wants to get into Q&A, so just a really brief 5 points to consider coming out of this presentation, if nothing else. You'll want to make sure any furloughed employees, students are available for their potential eligibility for the CERB and student benefit. If you are an employer yourself, you'll want to make sure you're taking full advantage of the CEWS and temporary wage subsidy. I say start the dialogue on CCRA. I mean, the dialogue's probably well underway if you're if you're aware of the Monday application deadline. So, I mean, there is a stack of paperwork that you need to get ready. Don't underestimate it. You'll see that when you go to the website. So if you plan to take advantage of it, probably better go in sooner rather than later. Tax, broader tax planning. I mean, we hate to try to find silver linings in a crisis, but if we do think taxes are going to increase. So if you want to reduce your long-term tax burdens, it's a good time to consider an estate freeze or refreeze. And likewise, it's a good time to consider broader questions of estate planning, such as, your will, your power of attorney, your kind of overall estate plan. So with that, we are always available for questions privately as well, but I'm happy to move to the public Q&A, and Anand's told me to stop sharing. So let's see if that works. Good. Anand, are you there? Yeah.
Perfect. Well, thanks, guys. Thanks for doing it, and we got a lot of good questions in the comment section. So I have a few questions that I'll pepper in here, but maybe we'll start with Myron Boyers' question, and I had this as well. In your slide there, you say that the landlord is expected to apply for other programs before this one. So Myron's question is, insurance doesn't cover any lost revenues. So what are other programs are landlords expected to have applied for? Siba, am I missing something?
Yeah. I can maybe add some color there. I think there's some provincial programs and grants in other provinces that have been released. And so I think the intention is that those be the first backstop, but I don't think it's relevant in Alberta right now, except to the extent that you're aware of another program that might be available, Anand. And then as far as insurance is concerned, I know that some people do have some stoppage insurance that might provide some relief, but obviously nothing to handle the scope of this crisis.
Then the second question that Myron posed here is, what if a tenant has stopped paying rent since March and has paid nothing since then, not even operating costs? This is the, we've heard this question from a few folks. If a tenant has paid 0% of their rent, how can they be motivated to use this program, or what are the, how would it work within the CECRA program?
Maybe I can address this, and I think that's also the following question relates to that from Chad. So in both situations, I think the way that it works is that the tenant faces a potential for eviction. So there's a win for them if the landlord agrees to do this program and the tenant qualifies for it. From the landlord's perspective, if nothing is being paid, well, the 50% that they receive from this program is 50% more than they would have received. And of course, that's for both the rent and the operating costs, as we looked at that one slide. So that's a win. There are programs we understand may be made available to tenants to pay that extra 25%. So again, if the landlord is getting zero, then 50% is an improvement over zero, and 75% is a bigger win. And if we can encourage the tenant to apply for the programs that they may qualify on that 25%, then that would be ahead of the game. The alternative, of course, is a tenant faces eviction, or the landlord gets zero for however long this continues on for.
Interesting. Chad had a nice comment. Thanks for the presentation, Ashvin and Michelle. One of Chad's questions here is that the provincial NDP has called for a ban on commercial evictions, as well as I think the federal NDP. Given that there isn't a Commercial Tenancy Act, how would this look conceptually at the provincial level?
That's a good question, and not one that I have an answer for. I think it's a nice idea to keep the economy going, but I don't know how that would be enforceable. And so I'm not sure how that would look. It is something that's been mentioned. We've heard that, but we don't know where that's at. And you know what, I'm just going to answer the rest of Chad's question. I just see it. Is there a mechanism under the program to allow the landlord to collect the amount? Well, the landlord can sue the tenant for that 25%. But again, if it's not available, it's not available. So that, I mean, if the tenant can't pay it because they've had no revenue and they're insolvent, then that becomes a practical answer as to whether or not you get recovery.
Yeah, from our end, I think it's not impossible to make a Commercial Tenancy Act to stand up against the against existing laws. What we've been advocating for at NAOP is that this is really a last resort, right? We don't want to see tenant evictions en masse. The program needs to be improved to the point that more landlords and tenants can use it, or that there's enough support for tenants. But the running of the economy isn't really it shouldn't be put solely on the landlord. And so what we want to see is that if there was a ban on commercial evictions, you wouldn't be able to collect rent from anybody, including the folks who can afford to pay it, and that would create a liquidity problem for landlords and eventually banks and municipalities. And so we think this is a real last resort kind of effort. What we really need to focus on is enhancing the CECRA program so that people can use that. I wanted to ask you folks, is there are there any tax advantages to using this program versus using a rent deferral program that a landlord might have already entered into?
Yeah, I mean, no advantages from a taxation standpoint, of course. Under a rent deferral arrangement, the landlord obviously is hoping to collect their full rent if the tenant is solvent and able to pay it at the end of the deferral period. But from a tax standpoint, the only difference would be that the full amount of the rent, assuming it's collected, would be included in income and subject to tax, which is probably what the landlord was expecting in any event. Whereas under the deferral program, our view is that the 25% forgiven, of course, would necessarily not be included in income and not subject to tax, and the 50% receipt from the government would also be subject to tax.
A couple more questions in the comments here, guys. What if the tenant is under a free rental zone during this period? I think if they're a new tenant and receiving free rent.
Good question. I don't have an absolute answer. I mean, I don't know if you could apply it. It's not specifically addressed in any of the agreements. If there was an obligation to pay the operating costs, and I think that would make sense. The terms of the agreement speak to what the lease says for what the base rent and the operating costs or the monthly amount is. So I expect as you fill that in and you say, well, there's no rent paid for that, then it would be only the operating costs that you'd be able to collect on. But I don't have an absolute answer. That's not been specifically addressed.
There was some discussion in the early on in the program, in the first release that CMHC put out, that you could substitute some months for other months. Could that apply in the case of free rent?
I don't know. I'm sorry. That's not something that I've looked into in any detail, and I'm not sure if the agreements address that, and I haven't seen anything on the website recently that specifically addresses that. Do you remember anything on that in that regard, Ashvin?
No, I don't. Yeah, I think we're stuck with the months that we're stuck with. All I would say is a lot of this is to go back to Michelle's comment about looking at it on a situation by situation basis. A lot of the items in the rent reduction agreements are by reference to the lease agreements. So how that free rent zone is characterized might actually bear heavily on whether what amounts are eligible for the program. So I think the advice would be just really to carefully scrutinize and work through that rent reduction agreement and see what terms it refers to in the lease agreement.
Yeah.
So that's a good segue to another question here. If the tenant never pays their 25%, just to confirm, that means that the landlord can keep the 50% paid by CMHC while taking 50% loss. So
keep it in what way? I mean, it's being paid from CMHC as a forgivable loan, and they would keep it, right? They get that in lieu of the tenant paying it. So yes, the tenant or the landlord gets that. Do they get the forgivable? Does the loan get forgiven? I think the answer is yes, because the tenant presumably qualified under their attestation and they never paid the extra 25%. So yeah, the landlord keeps that as long as all the other terms hold true and the loan is forgiven by CMHC ultimately.
Now, a question on if the tenant closes their doors permanently between now and December 31st, and the landlord is successful in getting the CECRA funding, would CMHC seek to recover these funds paid to the landlord?
So, sorry, can you clarify, is the tenant, so they ceased to operate but they weren't evicted by the landlord?
Yes.
Yeah, so I think as long as the landlord has abided by the terms of the rent reduction agreement, but notwithstanding that there was no ability for the tenant to keep operating, then I don't see anything that prevents the loan from being forgiven in that situation.
Because CMHC wouldn't go and try to recover those funds, they would just be counted as rent paid before the eventual bankruptcy.
Yeah, the tenant cannot be bankrupt at the time that they are filing this attestation. So that you'd have to look at the timing of that as to when that occurs. So if you had a tenant that was just trying to think if it's insolvent or just bankruptcy. If that occurs during the process, then you might have a problem. Yeah, so they can't be part of any actual or pending insolvency proceeding, and they haven't filed for relief under the Bankruptcy and Insolvency Act. So if you've got that situation currently in the midst of this timeframe, then that could be a problem.
Sure, but it sounds like it's mostly at the time of the application. Things that happen after that time probably less likely to be involved. But you know, yeah, maybe if that seems imminent, then it might be worth talking to a lawyer. Sounds like.
That's right.
Well, guys, that puts us at 11:58. So I just wanted to take the time to say thank you again for coming on and answering our questions on this program. It's, you know, really one of the largest programs that has ever been implemented federally for our industry in commercial real estate, and that's why NAB's been trying so hard to gather a coalition of developers from around the country, talk with the federal government as well as our provincial government about understanding our industry as they implement these large programs that are meant to keep the economy going. And I think it's a real recognition of the size and power of the commercial real estate industry in the economy. And so we're hoping that the rhetoric changes from a landlord versus tenant perspective to something something more like what each party is bringing to the table and how we can make sure the economy is improving and working over time. So thanks again to Ashvin Singh and Michelle Millard. I want to thank our sponsors. That's Quadrille, Qualico, Remington, and of course Panattoni Development. And thanks very much for tuning in, guys.
Thank you.